Hello, hello, hello. This is the Liberty Cause. I am back. I know I have been away for a while. Part of that was due to the very interesting election cycle we had this past year here locally. I know that the election cycle on the national level was, people are still talking about that. I'm not going to, but let me just say that here on the local level, we had some very positive change. We have a new county chair that is a constitutionalist. He is a great guy. And we have this new commissioner here in the city of Deltona, David Sosa. So tonight we are going to we're going to be talking about some heroes and some zeros. All right, I have a guest with me here this evening. We're going to call him Sam. Sam has been in somewhat of a battle with the City of Deltona over some really ridiculous issues, and I'm sure people have seen all the videos about the ridiculous code enforcement nightmares that people face around the country. Sam is a veteran. He is disabled. He's a veteran. And he was in both the Air Force and the Marines. Is that right?
I can't confirm or deny that, but yes.
Okay. And your disabilities, were they a result of your time in service?
Again, I can't confirm or deny that, but it's not about me being a veteran at this point. It's more about being disabled in general in the disabled community.
So do you kind of consider yourself, I don't know, maybe somewhat of an activist now for the disabled community?
I was forced in that position, but I accept it because when I took an oath in the military to support and defend the Constitution and my country and those unable to defend themselves, I couldn't help myself but find myself in that role and will continue to.
Well, there you have it, folks. Somebody who actually takes his oath seriously, who knows what that oath means, and that oath does not end when your time in service ends. So we're going to start off here with some video from a commission meeting. This was on March 1st. And we're going to start off listening to David Sosa and our Interim City Manager, John Peters. And we will interject when necessary.
Next thing I want to do is, I know, Mr. Peters, you and I have talked about a resident and some of the issues he's had with the city. We've met with him personally. And, you know, I know we're supposed to have an item on the agenda on February 15th. It didn't happen. It was supposed to happen today per our conversation. It still has not happened. The issue is with the lack of due process. He was provided during a special magistrate meeting, and we were going to look at waiving those fees and giving him his due process. I want to know, where do we stand on his case? And I'll let you go with that one first.
Okay. When I met with and Liberty Justice back in January, I asked for what ADA he was asserting, what was a reasonable accommodation, and we would try to come to a resolution and bring it back to commission if it's appropriate. I did receive subsequently an image of a doctor's note for a therapy dog.
Now, I want to point out, pay attention right there. He says, I received an image of a document for a therapy dog. No, what he received was it was a scanned image of a prescription for a service dog. Now, if you go to any ADA website and you look up under the ADA, look up service animals, you'll find out that there are very, very specific disabilities that will allow you to have a service animal under ADA. It is my opinion, and would you agree with me that on this opinion that he was clearly trying to misrepresent this to the commission to diminish the value of the disabilities that you have. Would you agree with that?
I would agree with half of that. I can't assume that he was trying that's what he was trying to do, but in my opinion, it appears that way from the way I see it, especially when he had the document in front of him and used a different word, which is a very different, distinct.
Oh yeah, legally there's a legal distinction between a therapy dog or a therapy animal and a service dog.
Right. One is protected under the ADA to be able to accompany you in any place that the public can go, and one is prohibited from. And there's a bit difference in their what they perform.
So, and again, you're certainly entitled to how you feel about it. My personal opinion, and again, it's my opinion, is I think that he was deliberately trying to misrepresent the facts. So we'll continue.
Not convinced that's what I'm asking for, but going back to the magistrate hearing, when you get notice of a magistrate hearing.
Quick question. He said that I'm not convinced that that's what I needed, basically what I'm asking for. On February 17th, in a phone conversation with you, did Mr. Peters or did he not say, send me the prescription for your service animal and I will take care of your code compliance issues?
Absolutely, and I'll add to that on February 12th or 21st at the meeting at the water company, he also asked for that particular same document.
Okay. And we do have evidence of that. So yeah, absolutely. He did say, send me this document, which we did, and I will take care of your code issues. But now he's telling the commission something different. I'm starting to wonder about whether I can trust this guy. I don't know. You be the judge.
It says on the form in capital letters, and I believe bold letters, that if you need an ADA accommodation, you are to reach out to the city clerk 48 hours in advance of the meeting. It is mine.
Okay, now, again, here goes my trust issues with this guy. He just said that on this document, you heard him, capital letters and bold. Not just capital, but bold. Not just bold, but capital. But let's take a look at the actual document. What he's referring to is right here. Persons with disabilities needing assistance to participate in any of these proceedings should contact the City Clerk Department ADA coordinator 48 hours in advance of the meeting at this phone number. The word dated is bold and all caps. Down here, the word Angela Myers and Danny Ron are bold, but not all caps. But I'm sorry, this does not look to me like it is bold or in all caps. So once again, he is misrepresenting to the commission, to the elected representatives. He is misrepresenting the truth. The truth is, we're looking at it right here. We cannot deny the facts. The facts are, this is not bold. It is not in all caps. Now I'm going to ask you, the particular accommodation that you asked for at that time that he's referring to on that day, what was that particular accommodation for?
It was a result of not getting the answer to my prior request for accommodation and asking for another accommodation that arose because of the stress, anxiety, and the panic attack that I was having about having a public hearing, just finding out that they denied my prior request for accommodation.
So let's talk about your prior request for accommodation. So the meeting he's talking about took place on January 27th of 2019.
23rd.
23rd?
Correct.
Okay. I stand corrected. January 23rd. I was actually there and recorded it, but January 23rd of 2019. And you got the letter denying your request for accommodation on what day?
January 23rd
Of
2019.
So January 23rd of 2019, you got your request denying, or you got the letter, and what did it say?
Paraphrasing, it acknowledged receipt of my letter dated December 3rd, 2018. I'm sorry, dated November 28th, 2018. That was delivered December 3rd, 2018. And at the last line it said that the ADA did not apply in the or your circumstance.
Is that enough?
No.
So, because of this, going back to 2018, for the past 3 years, you have pretty much just submerged yourself. You dove in the deep end of the pool on this.
I was forced into the deep end.
Yeah, they threw you in the deep end of the pool. They threw him overboard in the middle of the ocean is what they did. And that was in ADA law. So you've spent the past 3 years just literally absorbing information on this law and the case law that's part of it.
Right, when I'm able to, when my disabilities allow me to do so. But yes, for the greater part of 3 years, nonstop, incessantly, because they left me no choice.
About how many documents would you say you've printed?
7,000 to 8,000.
In 3 years, 7,000 to 8,000, and they can't read the emails that are sent to them. But you printed out and you read through all those documents.
Majority of them, yeah, 90% of them.
Okay. One question: at this point, would you say, given everybody that you have dealt with in the city of Deltona, in City Hall, the people that are called an ADA coordinator, the people who claim they were trained in ADA, blah, 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 would you say that you are more of an expert on this law than any of them?
In certain aspects, I would concur. On the building side, the building director may have more knowledge on certain things like the International Florida Building Code, but I don't think how the ADA applies to that. So yes, on the ADA side of things, yes.
So, and again, I just want to point out here that he got the denial letter, which did not specify with particularity why they were denying, because they didn't have a clue. They didn't know why they were denying. But he had actually, the truth of the matter is, and you heard Mr. Peters say that he put in for an accommodation at 5 o'clock right before a 5:30 hearing. That is true. That accommodation was for that hearing and that hearing alone, because he had just gotten the documentation, an hour or so before?
A few hours before, between 2 and 3 o'clock.
So he hadn't even had a chance to build a case yet. But he had actually filed for an ADA accommodation on December 3rd of 2018. So now we're at January 23rd of December of 2019, and they still don't know what to do with this. It's their job. They're supposed to have people dedicated to know exactly how to handle this. They're supposed to contact you, right?
Correct.
They're supposed to ask you some questions like, okay, can you explain to me why you need this accommodation?
Correct.
And then, and they're supposed to, either grant or deny based on a set of criteria that the federal government has laid down.
Correct.
Okay. And now we've got 2 months gone by. They haven't done this. Nobody's reached out to you. And as I recall, you told me that you went to Steve Rowland, who was at the time, had the title of ADA coordinator, and you asked him about it. And what did he tell you?
Two things. I asked him how the ADA applied to the city codes and ordinances. He said the only time that it would apply is by requiring to have a bathroom door opening of, I believe, 30 inches on the ground floor of a residence. That was the only time it applied.
But what about your accommodation?
And about mine, this was the 23rd, and I believe I told him that Cooper had issued a written decision on it, and it got kicked around from the head of code enforcement, between Dale Baker, I believe Richard Lovett, to the city attorney, back to the assistant city manager, Mark Cooper, and a decision had been made, and his response was, well, if it's decision's been made, it's above my pay grade. I can't help you on it.
Wasn't it his job to be the one to actually deal with it?
You would think so. He's the ADA coordinator.
And mind you, the guy who wrote the letter denying it, that was our former interim city manager, Mark Cooper, who's now gone. And let me tell you, they could not get rid of him fast enough. No matter what anybody tells you, they were looking for ways. They couldn't get rid of him fast enough. So let's carry on.
That if you need an ADA accommodation, you want to reach out to the city clerk 48 hours in advance of the meeting. It is my understanding, based on what's in the...
And let me just point out, and I'm going to have him back me up or tell me I'm crazy on this. When they say 48 hours in advance, that is if you need a physical accommodation. Like you need to come in a wheelchair, or you're bedbound and you got to be brought in a hospital bed, or you need to do it over the phone, or, I mean, like in your case, you're asking to do it privately.
Right. There are probably a lot of different disabilities, but there are two classes. One that's readily identifiable, a physical handicap that you can make out that may need to be accommodated for, somebody who has vision disabilities or hearing disabilities. Then you have those that you can't recognize, that are not readily identifiable, that might be mental health, or might be other physical disabilities that you cannot see that still might need to be accommodated.
So basically what they're talking about is like if you need a sign language interpreter or something like that.
Correct. Sign language interpreter.
That they need 48 hours in advance to get somebody in there.
And if it's physically inaccessible to somebody with a wheelchair, they may have to relocate to a building where it is physically accessible for a physical handicap, yes.
And aren't they supposed to have a sign language interpreter on staff or readily available anyhow?
Yes, readily available either under contract or employed with the city, where that's their primary function, where they have secondary functions that they can be doing in the meantime.
And they don't. Moving on.
File made the request for an ADA accommodation at 5 o'clock for a 5:30 hearing. That's not 48 hours. I was not aware of that until just last week. There's just information I need to.
Now, he was well aware of that before the prior week that he's talking about, because, 3 weeks before that?
Yes.
It was in January that we met with him, with Commissioner Sosa, who you saw there in the beginning. By the way, I cannot credit Commissioner Sosa enough. He has been fantastic through trying to help this gentleman with this problem, and every step of the way he has been there, doing everything he can. But he was in that meeting, and you brought up in that meeting that you had put in for that accommodation in December of 2018.
Correct. And on top of that, if I might back up a second, a few minutes ago he said that because that was what was in the file. Well, if he's referring to what was in the file, also would be in that file the December 3rd, 2018 accommodation. But he only referred to the one document being in the file, the one with the 48-hour notice requirement. And then one last thing on that is even that city rule, policy, procedure, custom policy is subject to the ADA, because you can't foresee something like a panic attack happening. So that is subject to the ADA. You can actually request an accommodation during a hearing, both in a magistrate court and in the circuit civil federal court at any time.
And people wonder why we don't trust the government.
Get in order to be able to pursue this. Like I said, did a lot of research on ADA over the weekend, some of which I plan to share with you all just for general knowledge. But this is a difficult case. It made all the more difficult because we actually came into compliance a week and a half ago. And
Okay, this meeting was held on March 1st, 2021. He said you came into compliance. You bent the knee to Big Daddy King a week and a half ago. When did you actually comply with their ridiculous rules?
I was forced to comply by removing it from my property just about the start of the COVID crisis, so around March of 2020.
So it's been about a year.
Yeah.
And but according to him, and you've got witnesses to this.
Correct.
And didn't you tell me earlier that you actually have someone that wrote you an affidavit?
Correct.
Oh, so somebody who's willing to testify in court that you came into what their version, you complied with their nonsense about a year ago. But he's sitting here telling the commission yet again that it was only a week and a half ago.
Right. A few things. Both my current neighbors where I live are willing to notice that, as well as where I relocated it to the person's home and their neighbors. So there's about 6 neighbors that can confirm that. And something here in the video will also help confirm that the city knew, because if he knew that I came into compliance a week and a half ago, listen to what he says in a minute about how he knows I came into compliance.
But so we got about 6 or 7 people that are going to say that, oh yeah, you've been in compliance for a year. And then we have this one numbnuts here that's going to say, oh no, he just did it a week and a half ago. Because that's what he wants this commission. That's what he wants the people we elected to believe.
documented in the file that he was in compliance. And then subsequently this last weekend, he had gone back out of compliance. Now, when he was in compliance, the issue is...
The weekend, what he says this past weekend, you came out of compliance. Did you or did you not have someone, code enforcement, don't know, but someone drive up and then back down your street and stop and photograph you in your driveway at your house, not once, but twice?
Right, as a result of the PTSD inflicted on me by the city, among other sources, I'm hyper vigilant, hyper aware, and it caught my attention when this person in a gray Honda CR-V slowed down, held her cell phone towards my driveway, towards me, and took a picture, reversed at the end of the street, turned around on me, came back and took another picture.
And you don't see it you won't see it in this video because it's really not relevant, but I spoke during this meeting that night, and I brought up and pointed out some other falsehoods. And just a few days after they did that to you, I sent you a picture of code enforcement parked on my side yard, trying to intimidate me. And I called and I got in touch with everybody on the commission, and I got in touch with this guy and told him, I said, you better stop. You're playing with fire. Of course, he denied it. He knew nothing about it, but, we'll just call it a coincidence.
Is primarily 2 trailers on his property improperly parked. When he was in compliance, he actually moved the trailers to another residence, and they were properly parked. We so noted in the file with an affidavit that he was in compliance, so his fine stopped at that point. His daily fines, which are about $37,000 right now.
So y'all heard that. A week and a half ago, we put an affidavit in the file, and we stopped the fines, which are at $37,000. But yet he came into compliance a year ago. Mr. Peters, you want to tell us where the hell that affidavit is?
Well, 2 things. First, he said that I came into compliance and that it was properly parked there. So A, they knew that I relocated the trailer. B, they knew where I relocated it to. And C, they knew that it was properly parked. If they knew that, they knew whether the trailer was not on my property at that time. And they must have known that it was not on there until this weekend. So you put 2 and 2 together.
And so we, like I said, we noted it, but then over the weekend, we noted that at least one of the trailers is still back on their property. I understand that.
And I want to point out here that we do have emails and text messages from him that the person who stopped by your house taking pictures. Now, you heard him just say, we noted that he brought one of the trailers back this weekend. But yet the person who was taking pictures, he knows nothing about that. That's just another coincidence. Like code enforcement sitting on the side of my house. These are all just coincidences in his mind.
I actually submitted a public records request for the records showing how John Peters knew that the trailers had come back onto my property. It came back, no records exist.
So there's no records exist of how he knows that the trailers came back, but yet somehow he knows. That kind of, and by the way, folks, and we're going to get into this a little bit down the road. We got a lot more coming this year, but I'm going to be talking about a public records request that I did, where I actually got back that no records exist, and I was already in possession of the record. So that's yet to come. But moving on.
He's trying to clean up his property and using the trailer as part of the cleanup process. But once again, the definition under ADA is, in order to be considered disabled under ADA, you have to have a major function that you can't do. Obviously, this gentleman is able to move the trailers.
So you heard it there, folks, that you're only disabled if there's a major function that you can't do. That is some medical terminology that you can take to the bank. A major function that you can't do. Now, I am going to defer to this very wise gentleman to my right, because he's the one who has spent the last 3 years delving into the actual law on this. Now, I will tell you that there are some people that I am very close to in my life, other than my friend here, that are also disabled. And they are not disabled because they lack a major function like walking or talking or seeing or hearing. There are how many different diagnoses would you say there are for a federally recognized disability, if you had to guess?
Well, it would actually be easier to say what is not a disabling condition that's protected and recognized, or that qualifies under the ADA. There are that many recognizable disabilities.
So let's go through a few. So PTSD.
PTSD would be one.
Eating disorders are considered a disability, right? If you're severely obese, is a disability. I know, I've seen that one. Osteoporosis.
Yeah, that would be one under exoskeleton.
The bottom line is there are literally hundreds of things. And you're going to see in another video that we're going to be putting out here soon, another one of our commissioners, Lauren King, and how he describes the invisible disabilities.
I just wanted to add on to that, just because my disabilities kicked in and I could not think. My brain froze, which is what happens when you have some of the disabilities that I have. But some of the physical and mental impairments include, again, they say are not limited to, and they include for a very reason, because the list is just so long, it's easier to say what's not. But some of them are orthopedic, visual, speech, and hearing impairments, cerebral palsy, epilepsy, muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes, intellectual disability.
So wait a minute, you said diabetes.
Yes.
That's a disability?
Absolutely.
But does that stop a major function? I mean, don't most diabetics just they control it with medication, and they continue about their lives, right?
There's an exception for that. The ameliorating medications that can ameliorate the disabling conditions, it's still recognized as a disability despite it being under control.
So you mean to tell me that somebody that did not lose a major function because of something like diabetes, or maybe they're fighting. I have another good friend right now that is being treated for brain cancer. He is still very, very functioning. He is still working, to my knowledge, when he's not, going through the chemo treatments. He still functions. But that would be considered a disability, the fact that he's got brain cancer, huh?
Absolutely.
So would that mean that what he just said was like pretty much 100% wrong?
Oh yeah, there's much more to it than he's even letting on. I wanted to reiterate something from before again because I forgot about it. He said earlier in the video that he asked me for a specific document, and I gave him that specific document on more than one occasion, in more than one instance, in person, on the telephone, via email. I said there are more than one disabling conditions. There are more than one. I reiterated to him, and I said I can provide evidence of certain ones or all of them, and then you have to consider the totality effect of all of them, plus the symptoms of those conditions and the side effects of those medications. But he specifically asked and only required the one documentation that he referred to in this video.
And not only that, after I provided that on your behalf for you, I followed up with him at least a half dozen times, and I asked him to be sure. I wanted him to put in writing to me, is this document sufficient? Crickets. That's what I got. Crickets. Why did he, what could possibly be his reasoning for not wanting to answer that question? It's got to be something that they're hiding, or he's hiding. But let's continue on.
So I'm struggling a little bit with the whole idea of ADA being a substantive issue in this case. So this is a very difficult case. We're working through it. I had planned to bring it tonight, but as I said, the circumstances are continually changing.
I want to point out here again just that what this really is all about is we've got an antiquated city ordinance that says that this gentleman cannot take the trailers, a couple of trailers that he owns, his personal property, and park them on his private property. So this is the government saying we're going to control how you live. We're going to control what you put on your property, how you park your own property on your own property. I have asked them over and over again, what is the governmental interest? Crickets. Crickets every time. Never get an answer. They can't tell me what the governmental interest is in this. If they're willing, if this is where we're at today, where the government is going to tell you what you can park in your driveway, what color you can paint your house, what kind of bushes you can have, and we're going to sit back and we're going to let this happen, whether it's a disabled person or not. Now, in his case, he is just simply asking for a reasonable accommodation, and he has very good reason. We're not going to get into the depths of the disabilities. That's private, but I will say that he has very good reason. Oh, and I also, I will, when we're talking about privacy, allow me to please point out the fact that Peters here even read that document and said, I've got a document here that is an image of a document, for a therapy dog. That was a violation of HIPAA right there. He violated his privacy by reading a medical record in a public forum, and then he misrepresented it on top of that.
Yes, disseminating it to the public, and there's a city personnel policy that prevents you from both reading medical records and confidential records and disseminating that information. These are both city personnel policies.
So this guy can't get it right, no matter what. It's like every time he turns around, he's screwing something up. And he's leading the city of Deltona down a path to, we were talking to one of the commissioners again here this afternoon, and we were adding up the potential. I don't know if you were here yet. It might have been before you got here. So let's go back to December 3rd of 2018. Should the federal government come in and they look at this and they say, you guys just, you not only dropped the ball, but you stomped on it, you put a hole in it and flattened the ball and then threw it over a fence where there's a really mean dog. Day one. Well, let's go ahead and give them, we'll just give them what the federal government would probably give them 5 days to start the process. So let's jump ahead we'll go ahead to, let's call it December 10th, just for, give them a little bit of wiggle room. So on December 10th, the federal government can charge a $75,000 fine against the city. December 11th, that fine goes to $150,000. December 12th is another $150,000. December 13th is another $150,000. December 14th, and I think you see where I'm going with this. Now, here we are at March 20th of 2021. When you start adding up all those days and all those $150,000 fines, we're pretty close to $600-700 million because pretty much the federal government can do what they want, and they'll take what they want. The city of Deltona doesn't have the capacity to fight the federal government. If they decide to hit them with millions of dollars, tens of millions, even hundreds of millions in fines, and then on top of it, we can go then to when the special magistrate found him, that basically he was in whatever they call it, contempt, or, that he found that, yes, he was in violation of the code, and we're going to start fining you. That was another. That would be another concurrently running violation. So $75,000 the first day, $150 the second day, $150 the third day, on and on and on. Then we come up to here in January, makes the next request for accommodation. Now we're into the third violation. Can the city of Deltona afford hundreds of millions of dollars potentially in fines because this guy right here doesn't know what he's doing? Clearly, he is trying to misrepresent things to pull the wool over the eyes of the commission. But can the city afford him? Can the city of Deltona at this point afford this guy who, because of his personal ego, cannot resolve this matter? And I know you wanted to talk about the federal laws and the city. Can we go ahead? Can you do that real quick?
Sure. So there are three laws, multiple laws. The ADA, which is 42 U.S.C. 126, the Code of Federal Regulations 28 CFR 35 that applies to the city.
I told you this guy knows his stuff.
The Rehabilitation Act, Section 504 of the Rehabilitation Act would apply. The Federal Fair Housing Amendment Act, and then the Americans with Disability Amendment Act. Those are the federal laws that would apply to the city. Then you have the city, state civil rights statute in 790 of the Florida statutes. You have the county civil rights ordinance in the Volusia County ordinances. Then you have the city. This was buried and the hardest to find, and that affected me the most, is to find the city policy or procedure that dealt with reasonable accommodations. It was in the transition plan that they allow for a reasonable accommodation to be submitted. And in that same policy, which mimics the federal laws, the city had 15 days within which to consult with me to ask if there was anything else they needed for that accommodation. Now remember, I submitted my request for accommodation December 3rd, 2018. January 23rd, I had not received an answer. That's significantly more than 15 days. Same thing happened on the January 23rd request that I submitted. It was unilaterally denied. They didn't inquire with me because I was having a panic attack, but instead, and despite me having submitted a request for accommodation, the magistrate called, despite me requesting an accommodation, to not have a public hearing and to have an advocate speak on my behalf. So he just ignored my second request for accommodation. And I want to note that each of those accommodations would stay any enforcement proceedings, and it shouldn't have even had to gone to the magistrate if they had followed proper federal law and city policy. This was to avoid the magistrate hearing and to accommodate me for an exemption, exception, accommodation, or modification of that ordinance. That's what applies at this point in the video.
So, folks, we've already been down this road so many times. Patty Gibson being unlawfully trespassed from the center for catching them breaking the law. Brandy White, and what she's been put through by the city for illegally live streaming while she was in City Hall trying to get records. These people cannot follow the law. They simply, is it arrogance? Is it ignorance? They just don't seem to care.
Yeah, but
Sir,
my question is,
so what you heard there in the background and the mayor trying to gavel me, that was actually me trying to set the record straight. That it was actually a service dog, not a therapy dog. Here's another problem with our government. And Heidi, I hope you hear this loud and clear. Your city manager was telling you he was misrepresenting the facts to you. I'm not going to say he was lying to you. I'm not going to say that he was just flat out fabricating. He was misrepresenting the facts to you when he said therapy dog. That's not what the sheet of paper, the prescription says. It says service dog. And all I wanted to do was set the record straight. But you see us lowly peasants. No, we're not allowed to set the record straight. So that's why people like this can get away with misrepresenting the facts to the elected representatives, and then they end up making poor decisions because they're working off of bullshit, essentially.
You and I talked, we agreed he was denied his due process. We should resolve that issue. He should have his turn.
Did you hear what he just said? Commissioner Sosa says, you and I, referring to Mr. Peters, met and agreed that he was denied his due process.
Yes, and we were both in that meeting as well, and I can absolutely attest, and we'll be more than happy to give testimony in court that, yeah, he absolutely said that his due process was trampled.
The special magistrate meeting. And, regardless, that part should be taken care of. And then we should set up a meeting with the special magistrate And at that point is where you come into ADA. As far as I know, ADA is more than just a physical issue. I mean, you have different, different criteria for ADA, and I want to make sure that we are covering all bases of it. I would like to get this resolved. I believe this started back in 2018, 2017, and it's been kicked down the road like some other issues. And I think it's time that we get some of these old issues resolved.
So I'm going to end that here. It goes on, with Peters and some more of his nonsense. But in this, I think we see who the hero is. The hero here was David Sosa, Commissioner Sosa. And I think we all know who the zero was. The guy who misrepresented over and over again. So I realized that, this video has gone longer than we wanted. But this is going to be first part in a series, and I promise you the next ones will be much, much shorter. We're going to be looking at some comments from the mayor, from Heidi Hertzberg, the mayor, her comments. We're going to be looking at some comments from Commissioner McCool and some comments from Commissioner Loring King. I'm going to put up here on the screen the contact information for all of the commissioners and for John Peters here in the city of Deltona. And I don't care where you are in the nation, you have a First Amendment right to seek redress of grievance. And I invite you to do just that, to seek your redress of grievance. If you don't like what you're hearing here, if you yourself are disabled, if you've got a friend or a family member, a neighbor, a loved one that is disabled, and this is how government thinks, what they think they can get away with and how they're going to treat you, you have every right to share that with these people and let them know how you feel. Now, as much as they're going, especially Peters, will want to call it harassment, because that's exactly what he does. He calls, if you call them out, if you seek redress of grievance under the First Amendment, you're harassing them. That will be a story for another day, that we will be making another video on him and his idea of harassment. But for now, just think about that. And, for all you folks out there that you think, well, you know what, this doesn't affect me. I'm just fine. Let me tell you something. You are one car accident. You are one slip and fall. You are one trip to the doctor being diagnosed with a deadly disease away from being put in a category that apparently John Peters thinks is a second-class citizen. You remember that. You're not guaranteed tomorrow. None of us are. And you're sure as hell not guaranteed that you're going to wake up tomorrow with the health you had today. Or by the end of the day tomorrow, you'll still have the health that you had today. People do stupid things. People drive recklessly. You may not be the one who's driving like an idiot, but you may be their victim. And if you end up needing an accommodation from the government because you've suddenly become disabled, do you want to have to go through 3 years of torture just to get it to the point where it's out in the open? I want to thank my guest tonight. He will be back with me throughout this series of videos that we're going to be doing. We've got a lot to cover, and again, I'm sorry, I know this one went pretty long, but this was one of the longer parts of this meeting that we had to cover. Did you have something you wanted to say real quick?
I do. Two things. Make sure you include the ADA coordinator's contact information, because they're the ones who are supposed to be actively involved with this but have not been at any point. And then I wanted to mention one more thing. even if you're not disabled or don't know somebody who's disabled, if you associate with anybody that's disabled, they're protected and you're protected. That's how broad the ADA is, how expansive the coverage and protection is. So if you know somebody that's disabled, the government has to accommodate you and them because you associate with them, so they have to provide accommodations even for people you associate with.
So there you have it. We will be back again with another video, shorter, I promise, here within the next few days. For now, I am the Liberty Cause. Please like, share, and subscribe, and leave us a comment below and tell us who you think is the hero and who you think is the zero. Until next time.